Welcome to our University Primer. Thank you for taking the time today to join us. I am Joanna Thurston, a partner in the chemical team at Withers and Rogers, and I'm here today in my capacity as a member of the higher education team to introduce you to Mark Caddell, partner in our trademarks team, who will give you a general oversight on trademarks and how you protect your brand.
Hi, I'm Mark Caddell. I'm a partner and chartered trademark attorney at Withers and Rogers based in our London office. What is a trademark? In simple terms, a trademark is a sign that can distinguish your product or service from that of another business. So take a very simple example. I have 2 bags of flour. One is called Mark's flour, one is called Phil's flour. You may buy one of those particular products based on the experience or the brand intelligence that you have, based on whether you like the Mark or Phil product and which one you want to buy into. So in simple terms, it's something that gives a consumer an idea of where that particular product comes from, where it originates, and gives you a monopoly in that particular brand to therefore protect the investment that you've made in any marketing campaigns you may have around the brand and just in getting that brand onto the market. So it protects you from others and distinguishes your place on the market. What can be registered as a trademark? Anything that is distinctive. That is the legal definition of what can be capable of registration as a trademark. So most commonly, unique words, things that have been made up and have no meaning in relation to the product or service for which they're going to be used. So to take an example, registering the word banana for bananas isn't going to work. Registering something that has got no meaning in relation to the product will work. For example, Dyson for vacuum cleaners. There's no correlation between the product and the brand name, so that's something that can be registered, as well as words, logos, sounds perhaps, colors, motion trademarks, a number of different things that fall within your brand identity can be registered as trademarks, and it's worthwhile exploring any external facing brands that you may have that make your offering yours and considering whether those can be registered as trademarks. What cannot be registered as a trademark? Things which describe the product service for which you're using the trademark cannot be registered as a trademark. But for example, if you are a bicycle manufacturer and you intend to use the brand Aerobike to tell customers that your bike is aerodynamic, that is simply advising the public that your particular product has a characteristic, and the brand name simply describes that. So conversely, on what can be registered trademark, things which are unique, have no meaning, terms which are meaningful in relation to the particular product or service, those cannot be registered as trademarks, and it's best to think about things which are distinctive and things which are unique to the offering that you have. And anything as well which may be considered a generic term in the space. So for example, fries in the chip market, for example, anything which is commonly used and is just a run-of-the-mill term for a particular product or service, that cannot be registered as a trademark. So think of things which are unique, made up, coined phrases. Those are all automatically going to fall into the distinctiveness camp, but things which just describe what you're doing, those will not be capable of registration. And that would also apply to any logos that reinforce that particular message. So to take the banana example, if you're a fruit seller and we're selling bananas and you had a logo that had a banana somehow stylized in it, that is not going to be something which you'll be able to protect as a registered trademark. What perhaps should not be registered as a trademark? I think one of the things to bear in mind, particularly with the idea of having a global trademark portfolio, so protecting a brand in different markets, one of the things which you must bear in mind in that situation is the cultural nuances of language and the way in which your brand may be translated in a local language or how it may be perceived in a particular market. If there are any negative connotations, you may wish to avoid registering or trying to use a particular trademark in that jurisdiction. With that in mind, it would be best to avoid using anything which may harm your interest in a particular market. So although they may be capable of registering, you as a business may decide that trademark registration and using a particular brand in that territory is not worthwhile. One of the things which the law frowns upon from a trademark perspective is attempting to register brands or images which may be considered offensive to public morality. So think about things like swear words, offensive images. Those things are not going to be capable of registration as a trademark, which often can be seen in creative marketing campaigns or things which are a bit off the wall. Some things to consider around trademark registration when offensive names or images are to be considered. Trademark searches. Why would you do one? One of the risks in launching a new brand would be that you launch a brand that someone already has trademark rights for. And one of the ways in which you can manage that risk is to conduct what we call a trademark clearance search. And that allows you to understand what is on the trademark register already and allows for an opinion to be given on whether or not you are free to use and register that trademark yourself. So before you invest time and effort, emotional and financial effort into having a brand developed, it is often very worthwhile to understand the state of the trademark register to find out if you're launching a new brand or applying to register a new brand is going to infringe someone else's intellectual property rights. Why should you register your trademark? Trademark registration gives you a monopoly to use that particular trademark for the goods and services for which your business has an interest. And one of the key things that allows you to do is to prevent any third parties using the same or similar trademarks for similar products or services of interest to you. So in a way, it gives you a real clear piece of the market in that brand and allows you to build your business through a particular brand in a better manner because you know that you have the trademark registered. So in short, trademark registration gives you a peace of mind that you're free to use that particular brand. And not only that, it gives you the peace of mind that you can prevent others from encroaching on your rights and gives you the tools to prevent someone else confusing people in the market and perhaps diverting custom away from your business to someone else's business. So to take an example like from earlier, if my bag of flour was called Mark's Flour and suddenly someone else arrived on the market with a competing flour brand under the brand Mark, you could see where my present customer base starts being mistaken and buying the other Mark flour product, and suddenly my revenue decreases, the other Mark's revenue increases. If I have a trademark registration for Mark for flour, I could stop that happening theoretically, and that would protect not only my business, but also protect consumers from being confused and perhaps purchasing a less good product, less well-made product, and having their own interest damaged. Another thing to bear in mind is that trademark registration is an asset, adds value to a business, so it's something that you can tell the world about, use the registered trademark symbol, for example, and that can be a way to increase the likelihood of you receiving funding for your new startup business, for example. Also on the asset point, it is something which you could license for someone else to use and generate income for the business that way. So in a way, it's not only passive right in that you have it on your books and you may never enforce it against someone else. You can actively use it to generate income and build the business in that way as well. So I think on the highest level, it is a tool for you to protect the investment you've made in a particular brand, and it gives you a monopoly in that particular trademark for which you're registered and allows you to prevent anyone getting too close to what you're doing, which protects your customer base and in all respects your business interests. Trademarks. How do you actually get them? The trademark application process is very similar from country to country. Essentially, you make a trademark application to the relevant intellectual property office in the UK, the UK Intellectual Property Office, and you will tell the trademark office the trademark that you want to register, so the name of your business, for example, and the products or services for which you intend to use the trademark. So in a way, this is quite easily tied to how you will use that particular brand and the products that you're interested in, for example. Once the trademark application has been filed, the relevant trademark office will apply its legal requirements to that particular trademark application to determine whether or not it is suitable for registration. So if it's simply a descriptive term that describes your product, the trademark office is likely to refuse the application. But all being well and it is distinctive, the trademark application will be accepted. And the next stage of the process is that it would be advertised to the public to allow for any earlier trademark rights owners to challenge the application, which is known as an opposition. So if you find yourself in a situation where perhaps you did not conduct a trademark search, you filed a trademark application for a brand that someone already owns, it's during that opposition period whereby they would challenge your trademark application officially at the trademark office with a view to the trademark office refusing the application because it's too similar to something that has gone before. Assuming all is well, no opposition, the trademark is acceptable for registration, the trademark office would then issue a certificate of registration, which would then have the trademark continue in force for 10 years. And a trademark can last infinitely so long as it's renewed in 10-year increments. One of the things that you must bear in mind as well is the use it or lose it principle. In most jurisdictions, this will be for a 5-year or 3-year period, where if you stop using the trademark for that particular length of time, a third party could come along and apply to have that cancelled, and you would no longer benefit from the trademark registration. How do you use your trademark strategically in a business? Trademarks are territorial, and one of the things which becomes apparent quite early on in considering a trademark registration strategy is that some of the considerations will follow quite nicely the business plan of the business. So if you have aspirations to grow the business in particular parts of the world, so say the US or North America, US and Canada is high on your priority list, the trademark strategy would follow that we may commence trademark registrations in the UK and Europe with a view to then taking those registrations and replicating them in the US and in Canada. So having the foresight to think of where the business is going to go and match the trademark registration strategy with that is always a good way to run the way to think about your trademark portfolio. Also, trademarks are for named goods and services, so you have to tell the trademark office what it is you want to register. So again, quite nicely tied in with the business plan, you may think that presently we are very much interested in selling clothing, but within the next 5 years, we know that we want to get a handle on selling luggage or maybe even perfume and moving into the cosmetic space. In that case, you do well to register your trademarks for all of those things at the outset to give your business room to grow and to avoid having to file new trademark applications later in time when you do actually come round to launching those additional product lines. One of the other things which is useful from a strategic perspective is having a regular review of your trademark portfolio alongside your business plan. So you may find that you have gaps in your trademark portfolio, that you may not have registered the trademark in particular countries that are now important to you. And that would be a springboard to then take relevant action to make sure the trademarks are clear for you to use and register in that particular jurisdiction. And one of the other things which is incumbent on any business really that's thinking about acquiring a new business, or if you're planning to invest in another company, is to conduct the right levels of due diligence to understand whether or not that business has the correct trademarks it thinks it does, or if it doesn't have any trademarks, to find out why not and where those should be protected. And all of these things come with cost implications, so it's very important to budget. And like I've said, with the business plan, there's something that you can include in the growth of the business. Where will the trademarks be? How much will they cost? And when will they be registered? You have trademarks, but how do you go about enforcing them? Once you have protected your trademarks, it is essential to have in place a system to monitor the use of your trademarks by third parties. So for example, if you have a trademark registered for your key product and there are a number of sellers on online platforms selling knockoff infringements, you want to be aware of those. So regular monitoring of your competitors, for example, or online spaces is a good way to ensure that the investment you've made in your trademark is not harmed in any way by third parties. And if you become aware of an infringement, it's very important to report that to the relevant person within your business and take advice on how best to stop that happening. So if you have a situation where you do have a counterfeiter selling fake products which are not authorized by you in any way and they bear your trademark, what you want to do is probably send to them a letter or correspondence to say that what they're doing is an infringement of your intellectual property and for them to stop immediately. That is the sort of headline, what is good practice in this particular space. One of the things that you don't want to do is fail to take action, and then your trademark just becomes something that everyone can use. So all the good things about exclusivity disappear in that your trademark just becomes common, what we sometimes call becoming a victim of genericide. It just is a term that's used to describe a particular product. And in that situation, anyone can commence using that brand for what it is you previously were known for, which is really something to be avoided. So failure to take action can have quite serious consequences. And one of the things that you may wish to do to help in enforcing your trademarks is have in place what is known as a trademark watching service. And that's something whereby you can monitor the trademark register, and this can be anywhere in the world, to find out if anyone else is making their own trademark applications which may conflict with the rights that you have. So if you get intelligence that someone has filed your particular trademark at the US trademark register, and in your business plan is that you want to go to the US within the next couple of years, it's good to know about these things so you can take action, or you can work out whether or not that's going to give you any problems for when you come to access that particular market. So really, your trademark registrations are only as valuable as your willingness to enforce them against third parties. There's no point in having a trademark registration if you're not going to stop others infringing it. So make sure you're aware of infringements, have reporting mechanisms in place, and take action to stop infringement when it does occur. I'm going to share with you a slide which has some examples of trademarks which may or may not be considered similar. So it is possible to enforce your trademarks against not only identical competing trademarks, so things which are exactly the same, Dyson versus Dyson, for example, but also things which are similar. And there is a particular way of assessing whether or not two trademarks are similar. And it's also upon the person that's trying to enforce their trademark to show that the products as well are in the similar space. So would, for example, beer and soft drinks be considered similar? They may be in the same place for purchase, in supermarket, for example, but would people actually think that the same business offers both products for sale? So on the slide, we have three examples of cases which are real, whereby the earlier trademark owner tried to stop a registration of another trademark based on similarity. So the first example is Arctic Storm versus I Love Storm. So in this example, both trademarks include the word storm. There's some connotation around what storm means, particularly for Arctic Storm when the Arctic has, again, connotations of cold, wintry weather. But in this particular case, the trademark office decided that these trademarks were not similar. So despite having the shared element storm, their general overall concept was deemed to be too dissimilar, and the trademark office would not stop both of these trademarks being on the trademark register. The next example is Fratelli La Bufala, which I believe is the Buffalo Brothers, and Buffalo Grill. Both have images of buffalo horns. And I think in this particular case, the collective imagery, dominance of the words buffalo and buffalo, which, as I said, essentially the same meaning, these trademarks were found to be similar. So despite having different elements on the trademark for Fratelli La Bufala, on the whole, they were deemed to be too close, and the trademark office decided to prevent the registration of Buffalo Grill. And in the third example, Vital and Fit against VitaFit, the trademark office again thought these two trademarks were too close. The reasoning being here that although the Vital and Fit trademark has a lot of graphic elements, as you can see, The fact that they only differ really in two elements, the letter L for vital and the ampersand for vital and fit, those were not enough to distinguish between vital and fit and VitaFit, and those were deemed to be similar. So this just gives you an idea of the breadth of protection that trademark registration can give you, in that it doesn't need to be an exact copy for your trademark registration to become enforceable. Things which are similar will also fall into the net of protection that the trademark registration allows you. The moral of the story is that to avoid any trouble, make sure your trademarks are as different as possible to the competition. When it comes to trademarks, what about company names? A company name does not confer the same protection as a trademark. There's often some confusion around the registration of a company, which is completely separate to the registration of a trademark. So in short, having a company name registered does not give you any of the rights that a trademark registration gives you. You're not able to license use of that particular name to a third party. You're not able to enforce in the same way the registration of the company name. And the best thing that you can do is to treat trademark registration as being completely separate to company name information, and making sure your company name is registered at Companies House in the UK, for example. Essentially, the company names register is just to tell the public that there's a company that exists, and gives you the mechanism to list your directors perhaps and file accounts. It's an administrative process essentially, whereas trademark registration gives you rights which you can enforce against the world. Thanks for listening. I hope this has been a useful high-level introduction to the world of trademark protection and what you should and shouldn't do, and given you some things to consider. If you're ever in the position where you need to ask yourself any of the questions that we discussed today, I would suggest taking advice and getting a professional steer on how best to develop and grow your trademark portfolio.
So thank you. We very much appreciate your attention today. If you have any questions, please email the admin email address on this slide, and your email will be forwarded to someone who can help.